it need not be a later also. Suppose in a given set of circumstances, it's in public media, everywhere, which cannot be disputed. All channels are showing something. Lord, I'm posing a question to myself, my Lord, can the governor not examine those facts also? But ultimately, he is not just, my Lord, when a 174, 175 situation arises, he is not supposed to be a mute spectator. He will have to act. His action would be subject to judicial review. Within, my Lord, the parameters which your Lordships have fixed, my Lord, for my Lord's, my Lord, future assistance. But please see, my Lord, 393, which is at, my Lord, volume, Judgment Compilation, volume 2, PDF 518. Lord, that's Bomai judgment, my Lord. Am I with your Lordships, my Lord? My Lord Justice.
And Lok Prahari and these 17 independent MLAs were backing the government up to then.
Yes. Yeah, yes. Seven, my Lord. Seven.
Not seven.
And, my Lord, one set of 393. In this connection, it would be appropriate to notice the unanimous report of the Committee of Governors appointed by the President of India. The 5 governors unanimously recommended that the test of confidence in the ministry should normally be left to a vote in the assembly, where the governor is satisfied by whatever process or means. Please kindly see, my Lord. It need not be a prayer that please hold a floor test, etc. My Lord. People are telling him that the government is not enjoying our support. They've lost the confidence. By whatever process or means that the ministry no longer enjoys majority support, he should ask the Chief Minister to face the assembly and prove his majority within the shortest possible time. If the Chief Minister shirks this primary responsibility and fails to comply, the governor would be in duty bound to initiate steps to form an alternative ministry. A Chief Minister's refusal to test his strength on the floor of the assembly can well be interpreted as prima facie proof of he is no longer enjoying the confidence of the legislature. I'm sorry, your Lordships. Lord, the subsequent event of the Honorable Chief Minister not deciding not to face, my Lord, justifies the decision that whatever material I gathered and the satisfaction I arrived at was a right satisfaction, that the government has lost the majority confidence. Now, my Lords, may allow me to place, my Lord, the Shivraj Singh Chauhan judgment, my Lord. My Lord, and that, my Lord, I would earnestly request your Lordships, my Lord, to permit me to read, because that was read by the petitioner, bits and pieces on, my Lord, this side, but not from the governor's point of view, my Lord. I'm sorry, my Lord, page 395, my learned friend is right, my Lord. Para 395 also in Bomai, my Lord. 395. Because it's not a luxury which is, my Lord, conferred upon the governor, my Lord, it's a duty.
392 or
395, my Lords, of SR Bomai.
And what is the PDF
Same
page? Can you give me?
518, my Lord, Judgment Compilation 1. 2, I'm sorry. The High Court, in our opinion, erred in holding that the floor test is not obligatory, if only one keeps in mind the democratic principles underlying the Constitution and the fact that it is the Legislative Assembly that represents the will of the people and not the governor. The position would be clear beyond any doubt. In this case, it may be remembered that the Council of Ministers not only decided on so-and-so to convene the Assembly on so-and-so, but also offered to prepone the Assembly if the governor so desired. It pains us to note, Lord, your Lordship, that's on the facts of the case, my Lord. The governor did not choose to act upon the said offer, and my Lord, that was frowned upon by the court. Indeed, it was his duty to summon the assembly and call upon the chief minister to establish that he enjoyed the confidence of the House. Not only did he not do it, but when the Council of Ministers offered to do the same, he demurred and chose instead to submit the report to the President. Lord, here I am being asked by the person who did not choose to face the vote of no confidence, that why did you call for the vote of confidence? Why did you call for the floor test? The converse situation and more drastic, my Lord, in terms of the facts. In the circumstances, it cannot be said that the governor's report contained or was based upon relevant material. There could be no question of the governor making an assessment of his own. The loss of confidence of the House was an objective fact which could have been demonstrated one way or the other on the floor of the House. In our opinion, wherever a doubt arises whether the Council of Ministers has lost the confidence of the House, the only way of testing it is on the floor of the House, except in an extraordinary situation where, because of all pervasive violence, the governor comes to the conclusion and records the same in his report that for the reasons mentioned by him, a free vote is not possible in the House. So, my lord, it's not his right, it's his obligation. Now, my lord, kindly come to, my lord, and, my lord, the threshold in my respectful submission is that some material which creates a doubt in his mind. And, my lord, I would, my lord, at the cost of repetition and with profound respect, my lord, please, this is a constitutional submission. Don't, my lord, misunderstand the submission. My lord, the threshold of your lordship's judicial review, which I am not disputing, would be whether there was any material, whether based upon that material, your lordships may perhaps would have taken a different view, may not be a test. Now, your lordships, my lord, kindly come to Shivraj Singh Chauhan, my lord. Volume 1, 1360, my lord, PDF 1360. Lord, I want your lordships to, my lord, see the contentions raised. Because that was not read before your lordships, my lord, and this would really be, my lord, illuminating and will assist your lordships to lay down the law correctly.
1360.
Yes, my lord. 1360 PDF. It is internal page 22 of Shivraj Singh Chauhan. Lord, this is the arguments of Dr. Singhvi, which my lords were pleased to, my lord, record. 17.2. My lord, I have marked my copy so that I don't have to, my lord, read everything. And your lord, I leave, my lord, something which is not relevant. Your lordships can trust my discretion on that, my lord. 17.2. There is a fallacy in the assumption that the governor has any locus to direct the chief minister to conduct a floor test to establish a majority on the floor of the House. Next, this court ought not to enforce the direction for convening a floor test, as it will have the effect of short-circuiting, as it was described, the large discretion which is entrusted to the Speaker on the matters of resignation by members under Article 190. Then, my lord, 17.8. The precedent of this court in regard to convening of the trust vote have arisen in the context of fresh elections held to the legislature and not in the context of a running assembly. My lord, Shivraj Singh Chauhan was a case of a running assembly, and in the midst of the, my lord, the government functioning, the then chief minister lost the confidence. This is what your lordships were dealing with, my lord. Now, my lord, kindly come to para 19. Again, my lord, submission. Elucidating on the above submissions, it was urged that the object of exercise undertaken by the so-and-so is to find a way around the two-thirds stipulation contained in the 10th schedule by engineering resignations of the 22 members in a running house. The submission is that if a trust vote were to be held before a decision has been taken by the Speaker on whether to accept the resignation of the members, this will pave the way for the 16 members whose resignations have not been accepted till date to abstain from voting. Their abstention, it has been urged, would alter the strength of the members present and voting, thus modifying the required majority in the House and impacting the outcome of the trust vote. Now, your lordships, my lord, kindly directly go to para 26, my learned senior Mr. Sibal's submission. Lord, it would be at PDF page 1363. 1363. Mr. Sibal contends that the observations of the Constitution bench in Nabam Rabia on the authority of governor to order a trust vote to be conducted on the floor of an ongoing legislative assembly are purely omitted. But Nabam Rabia was also an ongoing assembly, not first time government formation. The case before the Constitution bench in Nabam Rabia dealt with a situation where the governor had preponed the date for meeting of the Legislature Assembly to decide the question of Speaker's removal, it was submitted that Nabam Rabia is not a precedent for the proposition that the Governor is entitled to require a trust vote to be conducted on the floor of a Legislative Assembly, which has been duly constituted and is in session. Mr. Sibal submitted that the consequences of upholding the power of governor would be to encourage both the demolition of an elected government and the democratic structures of the governance. Mr. Sibal's submission, in Mr. Sibal's submission, governor would have the power to summon the House where it is not in session. Since under Article 168, the governor is a part of the legislature, if the House is not in session, it is open to a governor to seek a special session where facts indicate that the existing government has lost its majority. But this is in support of what I did as a governor. That if it's not in session and something would turn on his written another argument that no confidence motion was the only way and not the confidence vote by floor test. However, in a similar vein, Dr. Singhvi's submission, Mr. Sibal urged that this course of action is not open to the governor when the House is in session, and in such an eventuality, the only remedy is to seek a motion of no confidence to test whether the incumbent government is possessed of the confidence of the House. With respect to exercise of the power of the governor by calling for a trust vote, it has been submitted by Mr. Sibal that there must exist an objective satisfaction of the governor based on material in his possession. Absent a physical verification, it cannot be said that mere tendering of resignation by members led to valid exercise of power by the governor to call for a trust vote. Here, my lord, withdrawing support from the government. In the present case, the governor had no material to conclude that 16 members had submitted their resignations voluntarily. Legislative history in the country indicates that minority governments have survived, and unless it is shown that mere tendering of resignations actually caused the loss of confidence in the incumbent government, it is not open to the governor to conclude that actions of the 16 members would result in a loss of confidence.